My question is really very simple to you. Have you always been able to have a legal basis for the decisions that you have rendered and not have to rely upon some extra legal concept such as empathy or some other concept other than a legal interpretation or precedent?
Exactly, sir. We apply law to facts. We don't apply feelings to facts. Now,
thank you for that. Let me go back to the beginning. I raised this issue about the President's interpretation because he clearly is going to seek nominees to this court and other courts that he's comfortable with, and that would imply who have some commonality with his view of the law and judging. It's a concept that I also disagree with, but in this respect, it is the speeches that you have given and some of the writings that you've engaged in have raised questions because they appear to fit into what the President has described as this group of cases in which the legal process or the law simply doesn't give you the answer. And it's in that context that people have read these speeches and have concluded that you believe that gender and ethnicity are an appropriate way for judges to make decisions in cases. That's my characterization. I want to go back through the speech. I've read your speeches, and I've read all of them several times. The one I happen to mark up here is the Seton Hall speech, but it was virtually identical to the one at Berkeley. You said this morning that the point of those speeches was to inspire young people. And I think there is some in your speeches that certainly is inspiring. And in fact, it's more than that. I commend you on several of the things that you talked about, including your own background, as a way of inspiring young people, whether they're minority or not, and regardless of their gender. You said some very inspirational things to them. And I take it that therefore, in some sense, your speech was inspirational to them. But in reading these speeches, it is inescapable that your purpose was to discuss a different issue, that it was to discuss, in fact, let me put it in your words. You said, I intend to talk to you about my Latina identity, where it came from, and the influence I perceive gender, race, and national origin representation will have on the development of the law. And then after some preliminary and sometimes inspirational comments, you got back to the theme and said, the focus of my speech tonight, however, is not about the struggle to get us where we are and where we need to go, but instead to discuss what it will mean to have more women and people of color on the bench. You said, no one can or should ignore asking and pondering what it will mean or not mean in the development of the law. You talked, you cited some people who had a different point of view than yours, and then you came back to it and said, because I accept the proposition that, as Professor Resnick explains, to judge is an exercise of power. And because, as Professor Martha Minow of Harvard Law School explains, there is no objective stance, but only a series of perspectives. No neutrality, no escape from choice in judging, you said, I further accept that our experiences as women and people of color will in some way affect our decisions. Now, you're deep into the argument here. You've agreed with Resnick that there is no objective stance, only a series of perspectives, no neutrality, which, just as an aside, it seems to me as relativism run amok. But then you say, what Professor Minow's quote means to me is not all women or people of color, or all in some circumstances, or me in any particular case or circumstance, but enough women and people of color in enough cases will make a difference in the process of judging. You're talking here about different outcomes in cases. And you go on to substantiate your case by, first of all, citing a Minnesota case in which 3 women judges ruled differently than 2 male judges in a father's visitation case. You cited 2 excellent studies which tended to demonstrate differences between women and men in making decisions in cases. You said, as recognized by legal scholars, whatever the cause is, not one woman or person of color in any one position, but as a group, we will have an effect on the development of law and on judging. So you developed a theme, you substantiated it with some evidence to substantiate your point of view. Up to that point, you had simply made the case, I think, that judging could certainly judges could certainly reach different results and make a difference in judging depending upon their gender or ethnicity. You hadn't rendered a judgment about whether that they would be better judgments or not. But then you did. You quoted Justice O'Connor to say that a wise old woman, a wise old man would reach the same decisions. And then you said, I'm also not sure I agree with that statement. And that's when you made the statement that's now relatively famous. I would hope that a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion. So here you're reaching a judgment that not only will it make a difference, but that it should make a difference. And you went on, and this is the last thing that I'll quote here, you said, in short, I think this is important. You note that some of the old white guys made some pretty good decisions eventually, Oliver Wendell Holmes, Cardozo, and others, and you acknowledge that they made a big difference in discrimination cases, but it took a long time to understand, takes time and effort, something not all people are willing to give, and so on. And then you concluded this. In short, I accept the proposition that a difference will be made by the presence of women and people of color on the bench, and that my experiences will affect the facts that I choose to see. He said, I don't know exactly what the difference will be in my judging, but I accept that there will be some based on gender in my Latina heritage. You don't, as you said in your response to Senator Sessions, you said that you weren't encouraging that, and you talked about how we need to set that aside, but you didn't in your speech say that this is not good, we need to set this aside. Instead, you seem to be celebrating it. The clear inference is it's a good thing that this is happening. So that's why some of us are concerned, first with the President's elucidation of his point of view here about judging, and then these speeches, several of them, including speeches that were included in law review articles that you edited, that all say the same thing. And it would certainly lead one to a conclusion that A, you understand it will make a difference, and B, not only are you not saying anything negative about that, but you seem to embrace that difference in concluding that you'll make better decisions. That's the basis of concern that a lot of people have. Please take the time you need to respond to my question.
Thank you. I have a record for 17 years. Decision after decision, decision after decision. It is very clear that I don't base my judgments on my personal experiences or my feelings or my biases.